Great.
Okay, 3.3, Patricia Lundy from Ulster University has written to me, and again, I pass this on to the clerk for further circulation, and it's in relation to a request to brief the committee on the inquiry and redress scheme, and you'll find this on page 3 of your pack. So just to advise, Professor Lundy from Ulster University had considerable detail dealings with the HIA survivors and the Heart inquiry into that institutional abuse. And so she has a specific perspective of survivors who've participated in the process. So I suppose, given that we are only a number of weeks left in terms of taking evidence, I wonder, should we invite Professor Lundy to attend one of our stakeholder engagement events that are taking place later this month in the first instance?
Yeah.
Members' equipment?
Yeah.
Okay, thank you. Okay, moving on, members. Item 4 then, we've got the draft minutes. So just to inform you that you'll find these on pages from our meeting on the 1st of October. You'll find these on pages 16 to 25. And if you are content, I will go ahead and sign the minutes.
Great, Chair.
Okay. So matters arising then, 5.1, so the raised briefing paper responses to historical abuse in Great Britain. You'll find these on this briefing paper on pages 27 to 56 of your pack. You'll recall that we received this briefing on the 19th of March, and then I think we said we would come back to it whenever we were going through the committee inquiry proper scrutiny rules. So I think, Timothy, you've indicated to speak to this.
Yeah, it was pages 34, 35. It was focusing on how Scotland has approached the issue with a range of their inquiries. And what strikes me is they have approached it completely differently from what we have. To me, Scotland is like a best practice, or the nearest to what we're trying to do. And it just slightly concerns me that they have done it differently. And how they have progressed. I understand there will be more discussion about this in the weeks ahead, but I think that's something members should look at, as how Scotland have done it. And we always constantly refer to how they're getting money out of institutions up front, and there's a number of things in there where I believe we might need to look at closer.
Okay, no, that's a fair point. And anybody else got any comments on that?
No, great.
Okay, thank you. I wonder, Clark, could we possibly ask the department, without giving them too much work, whether they did give consideration to the Scottish inquiry or any others in terms of when they were drawing this up, just so that we can ourselves be satisfied that they have thought that the proposal in front of us is the best one for our particular circumstances here?
Certainly, yep, that's no problem.
Okay. Are people in agreement with that? Okay.
Great.
Thank you. Okay, so 5.2 then we've got. Oh, sorry, well, I think that was the same one there around the Scottish redress scheme, pages 57 to 62. Okay, we heard that on the 26th of March. Okay, moving on, 5.3, the AERC response to review of Assembly Committee engagement on cross-cutting executive strategies. And I'm going to refer you to pages 5 to 7 of your table pack. And I'm going to ask the clerk to speak to the draft response from this committee. Go ahead, please. Thank you.
Thank you, Chair. As Chair said, pages 5 to 7 of the table pack, just to make members aware, the Assembly and Executive Review Committee, or AERC, are undertaking a review on committee engagement on cross-cutting executive strategies, and one of the things that they have done is written to all statutory committees to seek views on that particular area. Obviously, that's something that is particularly interesting for this committee because by its very nature, our work is cross-cutting, and it scrutinises the work of the Executive Office, and the vast majority of work the Executive Office does has some sort of cross-cutting nature to it. So I have drafted up just a response back initially to AERC, just really saying that the committee welcomes the fact that it is looking into a review as to how this can perhaps better be done by committees, and also that just to explain that TEO leads on numerous cross-cutting executive strategies, and at times this can make it difficult for TEO committee to scrutinise the impact of these strategies when their actually delivery is resting with other departments. So the committee, I've also mentioned there, the committee is aware of procedures under Standing Orders 64. This is where you can have concurrent committees or dual committees to actually sit and then look at work. That tends to be when something sits within two different committees. But again, quite a lot of the work that TEO does sits in more than two departments in terms of its delivery. So again, members will see on page 6 that I've just highlighted the different things there. And then finally, just a couple of suggestions that perhaps AARC could explore, and we're on to page 7 now. Whether there is actually some sort of opportunity to create a committee that specifically just looks at cross-cutting issues and doesn't reflect the current structure of departments where we have a statutory committee for each department, but perhaps looks at things wider than that or on themes instead of that. So that's one suggestion. And then also something that has come up previously, I know within CLG in the past, is the potential for legislative forums between the civil service and the Assembly to look at legislation that cuts across different departments, just to make sure that the right committees are aware of that before it actually gets to the floor of the House. And it could be that this committee actually could hold a central role in that, just because it does tend to be a committee that looks at things across different departmental delivery systems. So that really was just what was in the paper, and obviously I welcome comments, Chair. I think, Carol, did you want to speak?
Yeah, well, I'm sitting on the Assembly and Executive Review Committee, so it's just to put that in the record. The only concern I have about CLG is it's a liaison group, and I don't understand why a liaison group would certainly look at something like this, particularly relating to statutory committees. So I think we need to just bring it back to ERC to try and recommend something.
Okay, any other views in the room?
Timothy, I think, would like to...
Just a brief one. I'm not entirely sure that we need another committee. I think it's a case of this committee, if it's coming out of the executive, and I think of ending violence against women and girls, and you think of the broad brush that has taken in of a number of committees where we had the Youth Assembly here that were very clear that if you want to tackle this problem, you tackle it through education. It sits with us. We are responsible for it. So to me, I think this committee, when it comes to ending violence against women and girls and other topics like it, we need to own that more. If the First and Deputy First Minister have said, right, that's the flagship of the executive, that's the one that we're leading on, well, I think it's this committee then that should be providing more of a scrutinising role into what the rest of the committees are doing and what the money's been spent on, and getting a feedback on what's the Minister's priorities around this.
Okay. Any other views on that? No. Yeah, no, I would agree with Timothy. I think that we do have that central role because of the First and Deputy First Minister chairing the Executive Committee, for example. Then they have overall responsibility for delivery, and it would allow us then to liaise across different committees as we see fit. So can it be amended to reflect that?
Yes,
please?
Chair. If I amend this and then circulate it around members, if we're in agreement, members could then agree the redraft, and we can get it back to AARC via email, if that's if everybody's in agreement with that, Chair.
Yeah.
Okay.
That's great. Okay, thank you.
Okay. Thank you. Moving on then, 5.4. The last week we had the presentation from the two academic witnesses, and so I'm just going to refer you to pages 8 and 9 of your tabled papers. There for a response from QUB and DCU on eligible applicants regarding the inquiry and redress scheme bill. So just to advise that the academics have advised that their research was qualitative rather than quantitative, i.e. examined the experiences of survivors and a range of stakeholders of justice processes and how they could be improved via narrative interviews. They do not have that kind of statistical information which is outside the scope of our research. So I suppose that was very good of them to come back so quickly. So are we content to note this item?
If I could just make a quick point.
Okay, so moving on then.
Sorry,
Go
Chair.
ahead, please, sorry.
Just a quick point.
That's okay, go ahead, please.
This is covering something we've essentially already covered. A lot of the groups that have given evidence We have asked about the list of institutions. When this panel was in front of us, we done the same thing with them. I just feel I haven't seen anything in the papers where somebody has come forward and said, right, here's more people. When they're in front of us, they're saying it's too narrow, but I haven't seen anybody turn around saying, but these are the ones you need to include. So it's reinforcing the point that was made earlier. This is a panel that has come forward with the additional information requested, but there's a lack of, well, these are the people you need to include in your list. Which concerns me that...
Okay. Okay, no, I think that's...
Happy enough, yep, go ahead.
Okay, no, I think that's more just for noting, is it, Timothy, or do you think there's an action out of that?
I think it's just something to highlight to committee, that time and time again panels are saying our list is too narrow. And when we have asked and information's coming in, that's what has stuck out in my head, that there's no additions to that list forthcoming. Time's moving on, and I would like to see that as soon as possible, if people are wanting us to include extra institutions on the list.
Okay, no, thank you. Okay, so are we in agreement just to note that item for now? Okay, so, item 6 there. So we had our first oral evidence session today was meant to be from the Northern Ireland Human Rights Commission, but unfortunately they are no longer able to attend today. So the committee, as you all know, is working to a very tight timescale in terms of the scrutiny of this bill, and so it is unlikely that we are going to be able to hear from the Commission in person before we enter our formal deliberations on the bill later on this month. So I'm very conscious that we don't want to delay the bill in any way. So you will have seen in your pack, members, that they did provide a very detailed written submission, and I would suggest that if any members have any follow-up questions based on that submission, that they provide them to the clerk by Friday of this week, and that they will be passed on to the Commission for response. So before I put that to the members, I'm going to ask Pam, if you want to come in now, please, Pam.
Thanks, Chair. Yeah, I was just wondering, because I've come in late to the meeting because I had a previous meeting, apologies. It was just, I've obviously missed the declaration of interest, and wondered, could I just interject now? Is that all right?
No, that's fine. Go ahead, please, Pam.
That's great. And it was just, it probably would need to go on as a standing, and I do have some wording in front of me. So based on the bill as it stands, we should declare that a family member may be entitled to a redress payment as part of the second part of this legislation. And so I was going to ask if this declaration could be noted for all committee proceedings in relation to the bill. Okay, thank you. That's noted, please, Clerk. Yes.
Yes, that is noted. Chair, just before we move on, I wondered if it was worth, with the fact that the Human Rights Commission couldn't make it today, but we do have our stakeholder engagement sessions, whether it would be worth inviting them along to one of those, if they can attend or not. Would you need to get agreement on that?
Great.
Yes, okay, so, yeah. So, and we're also in agreement that members would write to the clerk by Friday if they have any additional questions.
Great.
Questions? Okay, thank you. Okay, members, moving on then to our first oral session then. So we have the KRW Law, we've got the Law Society NI, and we've Phoenix Law now. And I'd just like to seek your agreement for Hansard to record this session.
Great.
Okay, members, I'm going to refer you to pages 164 to 168 of your pack for the clerk's brief, pages 169 to 178 of your pack for the written submission from the Law Society, pages 179 to 185 of your pack for a written submission from KRW Law, and pages 13 to 18 of the table pack for the written submission from Phoenix Law. So just to welcome to the meeting then, we've got Peter O'Brien, the Deputy Chief Executive of the Law Society NI, and Claire McKeegan, Partner Head of Litigation, Healthcare and Abuse at Phoenix Law, and Gary Duffy, the Associate Solicitor, an Associate Solicitor at KRW Law. So members, if I can ask you to all members and panels, if you can keep your remarks brief, and that we can maybe get to the questions as soon as possible. So I'll ask you to proceed. Thank you.
Good afternoon, Chair, members of the committee. The Law Society of Northern Ireland welcomes this opportunity to appear before you in respect of the Mother and Baby Institutions Inquiry and Redress Scheme Bill. As the committee is aware, we have submitted a detailed written paper setting out our analysis and recommendations of a number of issues which arise, and also look at the central role of solicitors throughout in relation to both parts of the bill, including the public inquiry and the redress scheme. As you've noted, I'm today joined by Claire McKeegan from Phoenix Law and Gary Duffy from KRW Law, both of whom have much more experience in this field than I have. They are on the ground, and they have recent experience of advising victims and survivors. In their opening remarks, Claire and Gary will highlight some practical concerns they have in relation to the current bill's draft and its practical outworkings from their perspective as legal representatives and their clients. In no particular order, Claire will focus on a number of issues, including the proposed terms of reference, posthumous claims, the level of payment, cross-border issues, access to records, and core participant status. Gary will cover issues including the proposed level of compensation, the core role of legal representatives throughout the process, the role of the advisory panel, the terms of reference, and the need for greater involvement from victims, survivors, and also the appeal period. In our submission and in today's discussion, we hope to assist the committee in considering how the legislation can best deliver an inquiry and redress scheme that commands confidence, meets the needs of victims, survivors, and provides wraparound assistance and support. Chair, I would propose that if we have introductions from Claire setting out her issues and those from Gary, and that if those could be got out of the way, and then happy then that the discussion would open up, rather than say, because there will be some crossover between the points that each of them will make, and it might be best then if the questions from the committee then look at that after they've both made their presentations, if you're content with that.
Well, I'm content, okay, but I would note that, we will have all read all the submissions, so I don't think we need to go into them in great detail, but if they just want to pick out some of the most salient, important points, that would probably be better to allow us to get down into the substance of the actual scrutiny. Thank you.
Happy to proceed on that basis, Chair. So, Claire.
Thank you. First of all, Chair and committee members, I wish to thank you for the opportunity to have us all here today to address you on this important bill. In the course of your work, you will have already heard from our survivor clients groups, Birth Mothers and Their Children for Justice, Birth Mothers and Their Children Together, and Truth Recovery NI. We have been working with survivors of institutional abuse in Northern Ireland since 2009, since they bravely spoke out of the wrongs perpetrated on them in state and church-run institutions. And when the HIA inquiry was established, these survivors were left behind as they fell outside of the terms of reference. Our clients feel very strongly that there should be no repeat of such mistakes in the legislation that's being considered by yourselves. We represent women and adoptees of Catholic and Protestant backgrounds and those without faith. This is an issue which touches 1 in 5 families across Northern Ireland, and many of us here today will have had a relative who was in one of these institutions. We represent over 200 survivors who were admitted to mother and baby homes across Northern Ireland. The criminal acts that were perpetrated in mother and baby homes are recognised in international human rights reports from the UN Committee Against Torture to be serious and grievous human rights violations. The crimes were committed in broad daylight on women and girls who were at their most vulnerable. They were denied the most basic antenatal advice, care, and described being given no alternative by social workers, their families, and the church than to enter a mother and baby home. Many of the babies were adopted and transferred outside of Northern Ireland into the Republic and onward. The levels of infant death in these institutions and beyond were alarming. Mortality rates spiked to 50%. They describe being verbally insulted and physically assaulted. And in some cases, women became pregnant as a result of rape, statutory rape and incest. These crimes were not investigated, and nor were they informed about their options in relation to having them investigated, their options regarding being able to care for their babies with assistance from society and from the state, and nor were they advised as to what happened to their babies, whether they lived or died. Many of the women that we represent are diagnosed now with serious mental health conditions as a result of the trauma that they have endured. The families put their faith in the Truth Recovery Design Panel and its findings, and the findings of the Truth Recovery Design Panel echo what they want and need from this process. They are disappointed that the bill does not reflect in full the findings and recommendations, and in particular with reference to records and cross-border issues. Our clients have engaged fully for many years, given their time and effort in coordinating responses to consultations. And it was with that in mind that we analysed the draft legislation and its ability to deliver and facilitate a full and robust investigation which includes survivors' voices at every turn, by keeping them at the heart of decisions, adopting the guiding principles set out by the Truth Recovery Design Panel, and being appropriately capable of effectively compensating survivors and victims in a manner which is commensurate with the crimes and harms inflicted on them. Sadly, many of our clients have died waiting for justice. Survivors must be given access to records at long last. This has been denied to them for decades. I'm going to talk about the various clauses in the bill which our clients take issue with, but I may do that in response to your question. So I'll pass on to Barry.
Sorry, no, Claire. Actually, sorry. Just before we go on, actually, I think as a committee, we want to hear more about the clauses. If you can just pick out some of the clauses that you think we need to particularly read into the record in terms of Hansard, that would probably be useful.
Okay, well the time limits are an obvious issue that I'm sure you will have heard about, and I know from the groups that they have raised this with the committee when they've been up, but the date in relation to posthumous claims should not be cut off in 2011 per the draft. Those who died before then are cut out. We learnt from HIA that is a futile exercise, cutting out individuals and having to redesign the process and delay and for people to pass on. This issue has caused a huge amount of hurt across the survivor groups. They are united on that. It is interpreted by them as cruel, arbitrary and cost-cutting. And it will be subject to legal challenge. Similarly with the HIA, the time limit was set and it was challenged by way of judicial review. And if that can be resolved now, it avoids further cost and further delay on the survivors. Then any legal challenge, of course, will delay their inquiry and their redress. The panel members is another issue that comes up. A chair from a judicial background is the path that has been chosen, and in many inquiries, this being a body of statute that judge sit it alone style is the preferred route, but our clients would wish that the judge would be assisted by a panel of multidisciplinary experts. They are abuse survivors with trauma that they carry and the need in any serious legal process, which this will be, and it will be very daunting and complex for them, that should be led by a multidisciplinary team that is cognizant of their complex needs. For example, an expert in trauma and health. Regarding institutions to be considered, the Truth Recovery Design Panel identified adoption-related institutions to include baby homes and private nursing homes. and other institutions than those mentioned in the list. We would be of the view that all potential pathways should be included, and if an extensive list, whilst we believe an extensive list should be annexed to the bill, but also to supplement that, the chair and panel should be given flexibility, that if another affected person from another institution comes forward, that the chair can and the panel have the discretion to extend the terms of reference in order to ensure that no one is left out. We must be cognizant of the fact that with the delay that this has taken, a whole body of survivors may be too ill to contribute, maybe just with the shame that they've had to carry all these years, feel that they can't come forward. So the small group of people that will come forward should be supported in the best way possible and shouldn't face any barriers to coming forward to assist this process. Compensation's an issue that has been raised by all the survivors in their consultation responses. The first issue is that the Truth Recovery Design Panel recommended that compensation in the form of human rights redress be provided urgently. Now, that recommendation was made 4 years ago, so the delay to date reinforces the need for an urgent action now, and we would be of the view that the standard and individually assessed payments should run in parallel with the inquiry, not just the standard payments. There is no benefit to survivors to have to apply twice. There's no benefit in administering a scheme twice. That would absolutely add to the cost of the scheme. And given the age of the survivors, any further delay in progressing to individually assessed payments will result in those who are entitled to significant amounts of money as a result of state failings, church failings, having passed away without having received the benefit of the redress owed to them by state and society as a whole. 54% of those who responded to the public consultation disagreed with the £10,000 standardised payment. This has been lifted from HIA redress scheme and is long out of date. Those recommendations were made in 2017. And the sum, when looking at harm done, must recognise that these are women who were abused, who had their children taken away, and a minor assault claim would attract a much higher level of damage. The deceased cut-offs is another issue. The legislation stipulates that those who can apply on behalf of a deceased person is narrowed to be a partner or child of the deceased. Obviously, in circumstances where we have adoptions and families being, they would say, torn apart by the treatment that they endured, leaves that very narrow line of eligibility to be unsuitable. Many of the survivors, as a result of these institutions, seen their families fractured, and they have suffered as a result of that. And to avoid unfairness, we would consider that there should be scope for an application to be made for a primary beneficiary in a deceased person's will, or where they can demonstrate on behalf of the balance of probabilities that it's appropriate for them to make a claim. This issue came to light in HIA also and was the subject of concern and dismay. In order to have a human rights approach with inclusion of survivors right through and from the outset, our clients would be of the view that even in the drafting of the terms of reference that they should be included, that they shouldn't be presented with a fait accompli, and that begins with core participant status at the very outset, to ensure that survivors can shape the process that they've waited so long for. our clients would desire and deserve to be given core participant status to allow them to fully prepare and participate in this, as I say, daunting legal process. It will be very distressing and re-traumatising for them to come forward and share their experiences and to allow society to learn from what they endured. And in order for them to be assisted, it's crucial that the core participants should entitle them, the core participant status will entitle them to be engaged, to be represented. The benefits of core participant status go beyond that, though. It's an ability to receive inquiry material, and as you know, right back to the outset, the blockage to getting their family history notes has been right up at number one of the survivors' asks and needs. So giving that material to them quickly, expeditiously, and with assistance to go through it of the desired legal representative is critically important in their participation of hearings. It also, through core participant status, they can ask questions of the witnesses, make an opening and closing submission, and be actively involved, and have greater visibility of the inquiry's work. Finally, another issue that comes up with the groups that we represent, the issue of institutions to contribute, and our clients would prefer that there was the inclusion of a legal mechanism to compel, not ask, the institutions and other agencies to contribute. There is a view that this scheme will, at least in part, indemnify these organisations who commit great wrongs, and they should contribute to that, to any scheme. The HIA inquiry recommended that the government could have recourse to alternative dispute resolution if there was an impasse. We're not aware of that having happened. It may be in the background, but that's one way of holding them to account. But we do understand that some of the largest institutions have yet to pay, and that's a matter of concern for our clients to date. But thank you very much. I can hopefully assist further, but that's what I have on my agenda.
Okay, thank you. Okay, Peter, do you want to go, or Gary?
Gary, I think at this stage...
I'll try to avoid going over ground that's already been covered by Claire. And I'd like to start by thanking you for the opportunity to address you today. We represent a wide-ranging client, including mothers, children, family broken up by enforced adoption, and the families of victims who have passed away. For our clients, this is a moment of profound significance, as the inquiry represents the first real opportunity to have their voices heard and their experiences acknowledged. For many, they had hoped they would be included within the HIA inquiry and were devastated when they were excluded. Since then, they've had to wait for over a decade. It's now incumbent on the Assembly to ensure that there's a real momentum in establishing the inquiry and the redress scheme, as well as ensuring that the process is victim-centred and caters to their needs. And for us, we believe the best way to ensure that the inquiry is fit for purpose is to ensure a central role from victims from the very outset of the inquiry. We believe that there should be a statutory obligation to consult with victims on the terms of reference and to consult prior to any subsequent amendment to those terms. So to assess that would be in relation to Clause 2. So we believe the terms of reference are vital in setting the parameters of the inquiry, and victim input will ensure that the inquiry can meet the needs of victims. It will also set an important marker that victims will be heard. We also believe there should be an obligation that the advisory panel is established immediately and that the panel remains active throughout the inquiry. It must be empowered to speak for victims and allowed regular engagement with the chair and other key figures. The panel can be a key vehicle of victim engagement, ensuring an established voice within the inquiry that can effectively raise concerns, provide oversight and accountability. At the moment, Clause 10 only gives the power to set up an advisory panel. It's not an obligation. We also believe that victims require independent legal representation at the inquiry. The institutions who ran these homes will undoubtedly be legally represented, and there should be an equality of arms between those that ran the institutions and victims. We also believe that legal representation can properly prepare victims, and this is including preparing statements of experience, gathering potentially relevant documentation, preparing victims to give evidence, advising victims on directions made by the inquiry, assessing materials provided, and acting as a conduit between victims and the inquiry to ensure that specific needs or adjustments are catered for. We believe we can be of practical benefit to the inquiry in helping victims navigate and effectively engage with the inquiry, ensuring that they feel comfortable providing evidence and ensuring them that their rights are protected. This will benefit both victims and the inquiry. We also believe there's an important role for legal representatives in assisting victims applying for redress. This includes in assisting preparing applications, accessing relevant records to establish residency if required, completing appeals, and advising on the legal implications of any award. It's all been covered, but I would reiterate that my clients feel much the same way as what Claire described in relation to the level of compensation for a standardised payment. That figure came out of the HA inquiry and the redress scheme there, and obviously that's now 7-8 years ago. They also take issue with the cut-off for the posthumous claims. For them, it feels unjust and unfair, and in essence creates a sort of hierarchy of victims depending on when someone actually passed away. We also believe that there's a failing in the redress scheme in that it doesn't reflect the institutions being investigated by the inquiry. It cuts out workhouses and things like that. Again, this creates a disparity between victims, with some receiving redress and others not. And finally, I would echo what Claire said. At the conclusion of the inquiry, and based on any findings made, institutions found to fault must contribute financially to the cost of the redress scheme. It's a cornerstone of restorative justice and ensures that any institution found at fault is held accountable. This desire for accountability is something that our clients feel strongly about. And so we believe that there should be a statutory obligation placed on the executive to attempt to recover funds at the end of the process. Hopefully you can answer some questions if there's anything else you're not sure about.
Okay, thank you. Go ahead, Peter.
I'm happy, Chair, for the conversation open at this stage, because I think as I indicated at the start, Claire and Gary are on the ground there, and whilst I'm sort of in the ivory tower of the Law Society, not directly in contact, and they have the experience and the points we make, I think, have been covered by them, and I appreciate that there's a desire to keep a momentum in the conversation today.
Okay, thank you. Well, thank you all again for your submissions. They were really very helpful for us to prepare for today. So I just want to pick up on a number of the points in that, and I think it was actually the Law Society themselves who indicated that there should be a definition included in the bill in terms of systemic failings. And I think it indicated that in the historical institutional abuse inquiry, there was a definition. Obviously, it was slightly different. But I'm just wondering around how we would get an agreement of how we would get that defined in a way that the victims and survivors, the birth mothers, etc., would find that acceptable at this stage of the process. Maybe that's the first one. Thanks.
Well, I think to some extent, Chair, that will depend on the whether or not it becomes an obligation to consult with those victims and the survivors, and whether or not in that the arrangements that would emanate from such an obligation, as to whether or not that is something that would be teased out or elaborated on in the context of those discussions. But as I say, I think it was something that we felt might assist the process if, in fact, some clarification could be given about what systemic failings actually were.
Okay, no, that's fair enough. So I think all of you are in agreement around the posthumous date for claims and the arbitrary nature in which the one that has appeared in the bill was arrived at. And I suppose he's also mostly covered the issue of the inclusion of those mothers who gave birth in the infirmaries in the workhouses, for example, and that they should be included. So I wonder if you could give your opinion on whether we should try to amend the posthumous date right back to 1922, even though we know, for example, that people won't be alive, for example, but in some ways it still allows for full acknowledgement of what all the women and the children went through.
Yeah, I think From my point of view, I think it should go back to 1922, mainly because somebody who suffered abuse or stigma or ostracization or their experience in 1930, it could be just as bad, just as impactful as someone in 1980, 1990. And if they passed away when they were 30 compared to when they were 90, they shouldn't be their family and shouldn't be excluded from that acknowledgement that they would receive through the redress.
I would certainly agree. Right back to 1922, although there may not be very many people who will be able to participate. Like I said earlier, it would be the view of our clients that this is a narrow group of people who will be willing and able to engage already, and to get the broadest level of evidence and contribution from those affected, the inquiry shouldn't be limited in terms of its time limit. So I would agree it should go right back. Indeed, some of the most serious infant mortality took place between the 20s and the 50s per the Queen's University report. So it would be disappointing and a failing, I would say, if there were sections of those time periods where it's closed off and the chair and panel are not able to hear that important evidence if it should come available.
Well, I was talking mostly as much about the redress scheme. Again, the numbers would be tiny, but I think that people would feel that their deceased relatives were included and acknowledged.
I think there's largely, but the principle of the matter, it might be tiny, but for the people who could avail of it, it seems manifestly unfair to say we have just arbitrarily cut you off, even though what happened to your mother, for instance, would have attracted compensation if she was still alive.
Yeah. Okay, last one for me, and to pick up on, I think, Claire, in the Phoenix Law submission, it was around the way that the £2,000 per eligible relevant person was prescribed, and I think there's some sort of concern that this would exclude some people, or that some people may not even know to apply, and that might result in then just maybe £2,000, for example, per mother. And I just wonder if you could maybe speak to how you think it should be set up for posthumous claims in a way that is fair and that doesn't then possibly drag out over several years where different family members come forward at different times. Thank you.
Thank you. Well, first of all, the majority of the families that we represent who lodged consultation responses said that the £10,000 should be at least doubled. And if you look at, and that's just for the standardised payment. Obviously, if you look at some of the most kind of lesser serious claims that come before the district judge's court, you've got damage levels between £3,000 and £15,000. So
Sorry.
it really, sorry.
So I was going to say, sorry, Claire, this is actually for the £2,000 for the posthumous claims, as opposed to the 10,000 standardised payment.
Yes, and your question is how should it be?
Yeah,
Well,
if
we
there's
think
another.
they should be fully entitled to the entire amount.
Yeah, okay, that's, and I'm just wondering how that could be split up across a family where they're maybe not in contact, because it's something I've grappled with. I'm not trying to trip you up here. I'm just wondering, is there a better way in which that we could propose this where there are multiple applicants for a posthumous claim for the same mother?
Sure, there was just one point in relation to scope, which I know in the conversations we had in preparing today, that Gary and Claire both had raised, was a sort of cross-jurisdictional issue, which I think I touched on when we mentioned this. But I understand that it's foreseen that there are particular difficulties where children have been brought across the border, and maybe Gary, you might want to say something more about that. Just
yes. There has been an issue, and I think it's been flagged up to the committee already, about Fawn and Donegal, for instance. There's obviously an issue about people who are now outside of the jurisdiction being aware of the redress scheme, especially if they were sent away and adopted. So we have clients in that precise position. about how they would engage with the scheme. In relation to how you would get multiple family members to avail of the posthumous claim, I think it was a feeling of the HA redress scheme that only one person could apply on behalf of a deceased, and then it was sort of the obligation was on them as the administrator of the estate essentially to hand out the money in line with that. It's particularly complicated in this situation where somebody could have a child very young, there was a forced adoption, and then they go on and have a family subsequently. A system where individuals just apply for their portion of the posthumous claim, I think maybe would avoid potentially people finding out that they have half siblings or something like that when they weren't expecting it.
No, I don't think that there's a perfect solution. Claire, anything to add before I hand over?
No, it is an extremely complicated one, obviously, but I do think that I would agree with Gary that they should all be entitled to apply, and I mean, my initial point is that the individual and standardised processes should be dovetailed together. And obviously there would be a much more significant award for an estate to administer. But
I do think if you had a situation where multiple people were applying for a posthumous award for the same mother, you would need to ensure that when it came to any individual payment that the applications were paired up, for instance, as well. You could have a case. You could have a case where somebody goes through a forced adoption and they could also apply on behalf of their mother, part of the estate, as well as themselves. But they might not know the experiences their mother had, and so when it comes to applying for the IAP payment, they have nothing to provide beyond I was through a forced adoption. There would need to be some way of pairing up their application with maybe half siblings who have applied on behalf of their mother as well.
No, that's a good point. No, thank you. Okay, I'm going to hand over to Timothy, please. Thank you.
Thanks, Chair. Afternoon all. Starting off, clause 26, time limit for applying for judicial review. So from the Law Society paper, page 6, obviously clause 26 lists the time for JR as 14 days, which is described as a significant departure from usual practice. What should it be in your eyes?
3 months. It certainly is the accepted time limit under the rules of the Court of Judicature, and that if you were to apply for JR even after the 3 months, there is the possibility of doing that, but certainly the courts take a view that 3 months is an appropriate period of time in which is required. I mean, you know, that 14 days for somebody to get notification, to even to digest it, and then to attempt to go and look for advice, for someone to take instructions, to make applications, to get some further support is a tremendously short period of time. And as I say, the accepted time frame within the rules of the Court of Judicature is 3 months.
Yeah, I think that's right. If you get a decision from the chair that you're not happy with, but you can't immediately avail of legal representation, say, you have 14 days then to think, is that decision wrong? Should I speak to a solicitor? Find a solicitor, and then they then need to brief counsel, prepare papers, potentially apply for legal aid if it's required. 14 days is an extremely tight turnaround for that, so it is.
My concern, I suppose, would be from picking this up is that if it's 14 days from the day a letter has been dated, by the time that posted out reaches you, that 14 days.
If there's a weekend or something, you're talking.
You can cover that, I suppose, by some presumption about date of receipt. So it's not necessarily the date that it's sent, but that there is some presumption that the time starts 3 days afterwards. But that's against the very point that, as I say, it's still a phenomenally short period of time for the reasons that Gary said out there.
I'm doing some research, so 3 months is obviously the standard. I've seen instances of 6 weeks or 30 days. Your evidence here today is it should be 3 months. That's what it should be. Moving on, in the papers you have said, and you've acknowledged victims and survivors, many of them have left the jurisdiction and now live outside Northern Ireland. Have you any best practice tips from the private sector as to how we can get our message out there to reach people?
That is a difficulty, and I know it from the HA redress scheme. It ran for 5 years, and yet still right before the deadline we were getting people ringing up, particularly from Scotland or England, for instance, being like, I've only heard about this and I'm panicking because there's only so little time left. I think you probably just need to take into consideration their age. So online probably won't reach the same level if it was a younger cohort. I know the redress, what was effective was things like ad campaigns and things like that, but it is difficult because unless there's groups that you can engage with, victims groups for instance, it's very hard to get the message out there effectively, but most of the victims groups are based here.
From previous experience, when somebody comes forward to yourselves, do you capture any data of how they've heard about HA or a different scheme?
Just through conversations with them, I don't know if it's any different for you.
You wouldn't have any data essentially?
We wouldn't. We don't keep track of it, but it would just be from anecdotally. People.
A lot of the survivors who are affiliated even loosely with a group would access the group via Facebook groups and access information that way, even if it's one of their daughters or sons or relatives that help them with that. Regarding contact with us, it tends to be word of mouth from another survivor. I know that in the HIA campaign there were signs on bus stops and on buses and newspapers. But yes, it is a difficult one to reach far and wide, particularly where they are maybe unwell.
Certainly I'm aware that Commissioner Ryan in relation to the redress board faced the same challenges, and particularly about people outside the jurisdiction. And I think from memory we certainly facilitated some contacts with the Law Society of England and Wales and the Law Society of Scotland, so that information could possibly be put out through those channels. But I think she made contact with sort of Irish organisations that were in London and stuff of that, in Manchester and the larger urban centres to see about disseminating information through those channels.
Common theme that's coming out of Schedule 2 and the list of institutions. I was wrong at the start of the meeting. I want to acknowledge there has been a couple of panels that has been communicated with me that have provided a list of institutions. So I just want to put that on record. I suppose one of the things that I'm concerned about is the institutions contributing. In Scotland, where you have the situation where there's two schemes but running combined, so you're applying either for acknowledged payment, if you're applying sort of in Northern Ireland terms, the acknowledged payment, or going for the IAP for what they've experienced. But once a victim applies, it then almost becomes a waiver. It does become a waiver for the institution, and on that basis then institutions have come forward and said, right, there's money, we're going to voluntarily put in money to this scheme. Your evidence would lead us in a different direction, where it needs to be based on the harms that have been caused, where they have facilitated, perpetrated or enabled abuse or systematic harm to contribute financially to the redress scheme. Have you any suggestions? What we've come up against is that we've been told that when we're applying the acknowledged payments on phase 1 of this, the acknowledged payment, that would be difficult to do. Have you any suggestions? I know, Claire, you had mentioned that both should run together. We're at a stage where that's not going to happen, but it's going to be the acknowledgement payment what we have here in front of us. Do you believe that when we get through this, when we would enter phase 2, that we should be looking to recoup not only the money for the IAP but also the money that's been paid out as an acknowledgement payment from them institutions?
I think it would be the feeling, I know from speaking to my clients, that they think they should pay towards the total cost. In terms of, for the redress scheme as its entirety. As for mechanisms, I'm not aware of a situation where legislation has forced the issue. I'm aware that typically the approach seems to be voluntary engagement, or a sort of carrot and stick approach where if an institution pays into a voluntary scheme, then they are protected from some amount of civil litigation, for instance. I believe that's been utilised previously. If you pay in, you get protection from civil proceedings. I actually think that was a failing in the HA redress scheme, that it gave every institution a shield against litigation and didn't require anything in return.
I agree, and whilst some religious orders will be cooperative, others remain reluctant, and we would be of the view that it's necessary for the bill to have some strong powers to compel engagement, whether providing evidence or contribution to the bill at the end, without any legal enforceability. We can't be sure that they will engage at all, and we would be of the view that right now at this stage, and that engagement should be taking place with the organisations to prompt that, because even our clients trying to hold them to account in the media doesn't seem to work.
Certainly was interested in hearing your thoughts on that, and that's something that has come through time and time again. It's not about the money, but it's about the institutions being held to account.
Held account, yeah.
And admitting some responsibility here financially. Last question for me is £10,000 for the acknowledgement payment. You've said, and we hear this time and time again, that it simply isn't enough, it doesn't reflect 2025. What should that be?
Our clients have said at least £20,000.
You're applying inflation from the £10,000, it would get you just below £14,000 as of today.
Well,
would you welcome a figure in and around that?
Well, we would welcome what our clients have asked for. We don't believe that the figures in relation to HIA ever went far enough, and this has been lifted from there. When you look at not only being incarcerated in an institution where all your rights have been eroded, you've been verbally and physically assaulted, and then it suffered the further indignity of having your child removed from you. I think that first of all, redress is supposed to be something that acknowledges wrong and assists the affected person to move on with their life. And if it becomes derisory or insulting in any way, that just adds to the harm. So we wouldn't depart from what our clients have asked for.
The one thing I would add just to that is, I know you mentioned if you included inflation, but I know that clients are concerned that if the IAP scheme only happens after the inquiry, that they might miss out the opportunity ever to apply just because of their age. They might have unfortunately passed away. So for some, the standard payment is likely going to be the only payment they ever receive. So that should be a factor in what the compensation is. For some, it will be the extent of the compensation they get.
Thank you.
Okay, thank you. Clark, did you want to read something into the record there?
Yeah, thank you, Chair. In regard to the judicial review and the timescale, the bill, as it is now, does say it's when the person becomes aware of a decision, not when the decision was made. So it's just to clarify that.
Okay, thank you. Thank you, Clark. Okay, next one I've got indicating here is Carol, please. Thank you.
Thank you. It's still too short. Let's just put that on the record. because by the time they're aware of a decision being made, they're still left with the scramble to try and get legal representation and opinion in that. So I think the point's well made. For me, so I don't want to cover what Timothy or Paula covers. I want to go straight to the public records end of it, getting access to information. So I've raised this from the start. I have a concern that this is a direct lift from the 2005 Inquiries Act, and it uses the instrument of a PII, which is a national security one, which for me just does not belong in here. I'm not saying there's not a need for some sort of mechanism to be added to the bill, the draft bill, by way of amendment, because we have heard evidence from panel members saying that they've had some of the religious orders who actually were more productive in the evidence they give because they were screened. I actually had the other view. I don't think they should be screened, but so it's just your thoughts on that. And then the whole issue of the access to records. So I want to declare this interest. I've done it every time it's come up, so just for consistency. As part of being responsible for public records, there was an undertaking, which is a non-FOI route. I don't understand why that's not deployed as part of this. And we're already hearing from the Health and Social Care Trusts that they haven't got the money to digitise records. And I mean, by the time you get the money, this inquiry could be over 5 years. So it's just if you would speak to that. And then my last question is around the core participant status. Did you have core participant status as part of the HIA?
No. That's one of the major criticisms from our clients. They felt that the institutions turned up with built-in braces and a full legal team, every single one of them, and they felt that they were left exposed, compromising.
Or traumatised.
And that shouldn't happen here.
And the institutions were the core participant throughout the entirety of the inquiry. Do you know, they got to make opening submissions, closing submissions, they were...
You prompted, sorry, my last question is, if core participation or core participant status is awarded to anyone, it should be awarded to everyone, really, is a point that I'd like to make. If the institutions are given core participant status, the only thing that I'm concerned about is, I agree with Timothy, I think there needs to be a level of compellability here in terms of making them give evidence, making them provide records, making them pay into redress. There's a voluntary arrangement at the minute, and I'm not really convinced, and I've no idea how successful it's been. But given the fact that they have withheld this in the past, I imagine we need to have an aspect of compellability. So that's the only thing about core participant status, that I do think the victims and survivors given evidence need to have legal support. But what that looks like, I don't know. Okay? Where would you... So the questions I've asked were about the public records, about the use of the 2005 Inquiries Act, and about ensuring that people have access. So it's up to yourselves where you want to go with that.
Well, I fully agree regarding the public interest immunity certificates. It would be particularly problematic for our clients who have campaigned all these years to compromise in any way the openness and transparency of this investigation. Whilst we appreciate there could be certain circumstances which require if it raises a national security issue, but this is to do with institutional abuse. It's not a legacy related matter. So
this should be about social services and welfare authorities and courts issuing adoption certificates, not legacy intelligence matters.
Where that would arise, and fundamentally it's a public inquiry. So it would defeat the purpose of a public inquiry to have either documents, witnesses, or evidence in any way screened or shielded from our clients. The media should indeed be encouraged to be there and to get the word out. One of the things I wanted to say, the learning from the COVID-19 inquiry and the Post Office inquiry with online hearings, how accessible and widely viewed that's been, and that should be encouraged here. One of the clauses in number 14, I just want to raise, gives the chairperson the power to permit and not permit admission to the hearing room. I would disagree with that. I think that that allows scrutiny to be limited, and the public are paying for this inquiry. They should be able to see everything that goes on within that chamber and be able to access it.
Unless a victim survivor asks otherwise.
Yes.
Okay.
Thank you.
I just have a point on the PII certificates as well. I was surprised to see that in the legislation, to be honest. Because like I said, this is about social services, bringing people across the border or taking women into homes. This isn't about intelligence matters. I noticed in some of the materials provided, there's a reference to this is normal or this is common in civil litigation, but there is other methods of deploying closed or sensitive material in civil litigation, including closed material procedures. If there was really something in...
Yeah, so could you provide that? I'm not asking you to do legal advice for the committee. All we're saying is that, I mean, we're in the process of looking at this as draft.
Yeah.
And if we're going to amend either by the committee or by individuals, we're going to need to provide examples of where it already happens that's not even reflected in this bill. And I suppose that's we're trying to give people protection, but not at the expense of the truth.
Yeah. So that was my point to me. There must be other methods of, if there is some small amount, I would have to imagine, of material that would fall under the PI, there must be other avenues of deploying it. So either closed hearings where it's closed to the public, or the chair and the panel get to see it, or something like that. There must be methods that isn't just the inquiry doesn't get to consider material.
Okay. Thank you, Chair. Thank you.
Okay. Thank you. I'm going to go to Philip, please.
Thank you, Chair. And just to go back to that point and continue on with Carol, was the previous point, though, that you didn't want the Chair to have power to be able to move into closed session?
I think there's a point about generally the position should be it is open as possible for oversight and accountability, but so I can also appreciate there will be times where it is appropriate, but it should be used sparingly and when it needs to be.
And following an application.
Yeah, so you don't think the safeguards provided in 15 in relation to 14 are strong enough? So there are the restrictions that they would have to follow if the chair of the panel was to move into closed session. So it'd just be worth at some point if you've got a wee read of that and your thoughts on those restrictions. I just wanted to pick up the posthumous cut-off point. So your views on behalf of your clients is that should go back to 1922. Do you know how many of your clients or how many people in Northern Ireland that would bring into the scope?
I don't have any clients that would go back that far.
Okay.
That's why I did say
sure.
It's about the principle
of
the
course.
matter about
100%. Not sure.
We wouldn't have it. No, we wouldn't have any that would go back that far.
Yeah. No, totally. That's okay. And then see the core participant status. So that would be the view then that those people would have their legal costs covered. Yeah. So this isn't
a clause.
So this isn't the view that I'm articulating, but someone who watched online could say, well, of course, representatives of the legal sector are going to come along and say everyone should have core legal or participant status because ultimately legal firms are going to be the beneficiary of that through fees. How would you answer that?
It would be victims who will be the main beneficiaries of it. For many of them, it's very difficult to come forward to talk about their abuse. In the HA redress, they show up in what looked very like a court environment, and then they were put on the stand, and for many of them they felt like they were being cross-examined or they were on trial. I think legal representatives can play a role in ensuring that they can give evidence to the best of their ability, and assure them that that the processes are working. That was something that came up quite a lot in redress. People feel like there's something wrong. There's solicitors and legal representatives can play a role in assuring them that that's not the case if it isn't, or keeping them right and advising them on things like judicial reviews if needed.
Mm-hmm. And then you had said earlier then your view would be that through core participation status, legal representatives would help them fill out application forms for the standardised payment. Is that right?
Well, yes. If you were representing somebody, then you would obviously assist them in that.
And have you given any thought to like what the financial implications of that decision would be if that was taken in relation to this bill?
In what way?
In what way? Of how many people would become core participants, what the likely average bill that would be submitted on behalf of those clients would be, and ultimately how much then we as a committee would need to be cognizant of if we make that decision, what the impact on the Northern Ireland budget would be.
I think it would depend on precisely what it means by core participant status. It might be different for some people. It might be simply just providing a statement.
The group could become.
And also, one of the ways other inquiries have combated inquiries cost spiralling would be to have legal representatives looking after particular groups, which that's been done in COVID-19, for example, and it's not only about attendance and preparing a statement, but also inquiries produce and churn out a deluge of materials that traumatised quite often survivors and victims have to then grapple with and get through and respond and prepare questions for witnesses. If they don't have legal advice and assistance to help them do that, they're not going to be able to participate with a fast running inquiries timescales, and their voices will get lost in the process. So it's critically important, and from European human rights standards, the minimum standard.
Did you not say earlier that during the previous one that Carol had asked that they weren't given?
They weren't, and that was challenged.
What was the outcome of that?
Well, in the High Court, the victims were successful, but in the Court of Appeal, it was found that the victims wouldn't get status at that stage because the inquiry had concluded almost its evidence. But it's well acknowledged, and if you look at OMA, if you look at COVID, if you look at Post Office, if you look at Muckamore, all of those families in recent history of public inquiries have been given core participant status, so there shouldn't be a departure from that for these.
My final question is just in relation to the widening of the scope of the deceased person who can apply for the posthumous claim. Maybe picked up the word wrong, so that was your view would be that should be anyone who on the balance of probabilities could prove that they had a connection, or they should be they have a, what was the term in which you used the balance of probabilities? That was just in relation to the widening of the scope of the people who can apply for.
Yes. For the posthumous claim.
Yes.
Sorry.
No, don't worry. There's so much of it.
I think it was early.
Oh, was it?
Okay, start.
I know this became an issue with redress because it's similarly limited, and you would have situations where someone potentially could have died quite young.
Yes.
Largely because of the impact. And I know there was a real feeling amongst. Well, I know for our firms were contacted in the past by maybe brothers or siblings or something, saying they never had a life. I was the closest, I was the next of kin, but they were excluded. So you would have situations like that where
Beneficiary,
a family.
Yes, because these families have been separated, And this also came up, like Gary says, in the HIA inquiry, where families separated, adopted, different, maybe didn't have the records, etc. But the next of kin or a partner was left out. For example, if I have cohabited with a partner for X amount of years, but I'm not on the birth certificate as or married, that I can't prove and I'm ineligible, well, that presents an unfairness because of what really are the outworkings of what the state have inflicted on these people. So if they're able to establish and demonstrate to the panel who are assessing the claims that they have that relationship and that they deserve to be given an award, then that should be appropriate.
And then the panel would make the judgment of the balance of probabilities, is your view. Yeah. Okay, that's perfect. Thank you, Chair.
Thank you. On you, please.
Thank you, Chair. Just to go back to clause 14.2, I think it was actually 2B, in relation to no recording or broadcast of proceedings at the inquiry may be made except at the request of the chairperson. I think both Philip and Claire yourself had previously touched on this. Is that standard procedure at all? Obviously you've mentioned it wasn't standard procedure for the COVID-19 inquiry. I suppose I'm just trying to drill down as to why it's been included within the draft bill, or why you think it's been included.
I do think there's probably some protection in that in relation to victims, but it should be paired up with either attempts by the inquiry itself to make watching it available online, so that there's no need for other people to be recording it. I think obviously that the inquiry controlling that stream ensures that you strike a balance between trying to have as much of it publicly available as possible, but also ensuring that victims can feel like they can actually give evidence, because it will be the case that many probably will want to be ciphered and to be anonymised.
And that'll obviously be, I'm assuming, decided by the chair.
Yeah.
And Claire, I think it was within your written submission as well, just about possibly a minor amendment with the warden around the, let me see. Yeah, it's at the request of the chairperson, with the permission of the chair and in accordance with any terms on which permission is given. The second point was for you, Gary. I think you had touched on it in your oral contribution around the statutory obligation to be placed on the executive to recover finances from institutions. I suppose, how would that work in practical terms? Obviously, I don't know, would there be any legal issues around, and no doubt we'll probably have to take our own legal advice on it, but if we were to include that in this draft legislation, what would that tangibly look like?
I did want to, in my submissions, keep it vague, because I do appreciate the precise mechanism to which you do it. I don't think is abundantly clear, because I said I've never seen a case where the legislation has forced payment, but the idea being that to place an obligation on the executive or a particular minister would then be a spur for them to create a mechanism, whether it be by forcing payment in some way or through voluntary contribution, or, like I said, offering something in return for engaging with the scheme. That was the thing behind creating as an obligation, where they had to then create secondary legislation or further legislation in order to reduce the cost.
That sits in with the compatibility element of it as well. But I don't know if anybody else wants to feed into any of that.
Well, I think it adds, becomes an additional pressure point. But how you actually formulate that, I mean, I share Gary's concerns about how we might actually draft that, or what it might actually look like. But it's all about sending a message and saying, you know, that there is something here
victims could see that and know that there is a legal obligation, and it's not just going to go into the long grass, and it's never going to be chased, and it's going to be 10-15 years down the line, and there's been no attempts to get accountability for them from the institutions.
And I suppose that's most likely going to be the challenge for us as to how we actually get that down, down in writing and drafted. But thank you, Chair. Thank you, folks.
Okay, thank you. Okay, panel, thank you so much. That was a really good session. I think we got a lot out of it, and certainly, as I say, the papers you submitted in advance were excellent. So thank you very much. Okay, members, we're just going to move on to our next panel, if that's okay. So item 8 on the agenda. So I'm going to refer you to pages 186 to 189 of your pack for the clerk's brief, and then pages 190 to 195 for the written submissions. So we're going to hear from the Truth Recovery Independent Panel, and I'd just like to seek your permission again for Hansard to record this session. Is that okay?
Yeah.
Okay. Okay, so I'll just give a wee minute for them for the team there to change the table there, the settings. Okay, well, welcome. So today we have Professor Leanne McCormick, Independent Panel Co-Chair, the Truth Recovery Independent Panel, along with Professor Sean O'Connell, the other Co-Chair, and then we have Mr. Colin Smith, SC, who's a human rights barrister. So thank you all for coming to committee today, and thanks for your submission in advance. I'm not sure how you're going to do it, if you just want to speak to your submission or make some opening remarks.
Thank you very much, Chair, and thank you very much for the invitation to come to discuss the legislation today. I'm just going to actually hand over, if that's okay, to Colin, who will give our opening remarks.
Thank you very much, Chair, and on behalf of the panel, I'd like to thank the committee again for the opportunity to speak to you about the bill, developing on the ideas that are contained in our written submissions that you've already received. For my own part, as a senior counsel representing victims and survivors of institutional and human rights violations in the South, I want first to commend the Executive for having avoided so many of the mistakes made by successive Irish governments. Broadly speaking, we think this is a very good bill, but there are obviously key aspects of it that require to be amended and improved so that the promise of the Truth Recovery Programme can be realised for victims and survivors and their families, and for all the people of Northern Ireland. And in that context, we have 3 observations to make on part 1 of the bill relating to the public inquiry, and 3 then to make on part 2 as well in relation to the redress scheme. So, as far as the public inquiry is concerned, first, the panel considers that clause 3 on the scope of the inquiry is sufficiently broadly framed to allow regulations to be made which can encompass the range of institutions and experiences which should be the focus of the inquiry's investigation. The question will be, of course, how those regulations are framed. And putting the list into regulations rather than into the Act itself does avoid the risk of creating a hierarchy of institutions, one group in the parent legislation and one in regulations, while at the same time it does make it easier to amend the scope of the inquiry if that should ultimately be determined to be necessary. Our second observation relates to participation, and the committee has already heard recommendations that the establishment of an advisory panel, including victims and survivors, should be mandatory rather than discretionary, and we certainly don't disagree with those submissions. But we note again that the design panel recommended that victims and survivors would participate in the inquiry panel itself. And given the participation of 3 victims and survivors on our panel, this is something that we feel that we need to raise again. In our view, the legislation is broad enough to permit this, but whether it actually happens, of course, is another matter. And of course, the composition of the inquiry panel will have a very significant impact on how the inquiry operates. And that brings me to the third observation, which doesn't relate specifically to the bill, but rather to the rules which would be made either under Clause 13 or Clause 27 in relation to the actual conduct of the inquiry. Now, it is desirable that rules should be made under clause 27, in our view, to contain special measures for vulnerable witnesses to ensure that mistakes that were made at previous public inquiries with regard to the treatment of victims and survivor witnesses are not repeated. Now, we understand that the special measures adopted at the Mucklemore Abbey Hospital inquiry are working very well, and in our view it would make sense for them to be incorporated here into the rules for the operation of this inquiry as well. So turning then to part 2 of the bill, which is the redress scheme, here again we have 3 concerns, and we've tried to avoid repeating things which the committee has already heard. First is obviously the exclusion of the workhouses. As we understand it, the workhouses were included within the scope of the Truth Recovery Programme, principally because women who were resident in them and gave birth in them had similar experiences of discrimination to women who were admitted to mother and baby homes, and that this also applies, of course, to their children. Now, that being so, we struggle to understand the exclusion of this comparatively small cohort from redress. With respect, we don't agree that any such inclusion would offend against the anti-discrimination measures of the Northern Ireland Act. And we think that any administrative difficulties that might be associated with their inclusion are not unsuperable. Second, there's the issue of the relevant date for posthumous claims. For us, as for so many people who have spoken to the committee already, and indeed, as I understand from comments that committee members have already made, the current date simply doesn't make sense. At the moment, payments are the only form of acknowledgement of suffering contemplated by the bill. And when the issue of acknowledgement is so important for people, it's hard to see why, in principle, eligibility should not be backdated to the foundation of Northern Ireland. And the third and final point flows from this issue of acknowledgement and the potential for compounding historic harms by conflating financial payments based on notional dates of expectation with acknowledgement of suffering of people who are no longer with us and the intergenerational effects of that suffering. It seems, based on our engagement with victims and survivors, that much of the distress caused by the suggested date of eligibility flows from the fact that payments are the only form of acknowledgement that the Act contemplates. And we suggest that it may be possible to confer on the redress service a power to offer acknowledgement apart from financial redress, which could be conferred on the redress service, and that this would be especially appropriate if ultimately a date other than 1922 is settled upon. So these, members of the committee, are the improvements that we as the independent panel suggest could be made to the bill. They're based on our own expertise and our experience, including the expertise and lived experience of our victim and survivor colleagues, and we hope that they'll be of assistance to the committee in your important work. Thank you very much.
Okay, thank you very much. Sean or Leanne, do you want to make any comments at this stage?
No, I think we're both fine. I think Colin has spoken for us, so we're just happy to take questions.
Well, thank you very much. Okay, so just want to pick up leading from our last session there, and it was around the comment there around putting the birth mothers and the adopted children, for example, on the stand, and the potential adversarial nature of the public inquiry. And I'm very conscious that your panel have taken a lot of testimony and you're working through that. And I just wonder what needs to be included, in your opinion, in the bill or even the committee report to reflect the importance that the inquiry panel should or could place on the work that you have undertaken to date. Thank you.
As a starting point, Chair, is just to go back to the Truth Recovery design process, which created the Truth Recovery independent panel to be followed by the public inquiry, with one of the major aims of doing that was to collect testimony in the non-adversarial fashion that we have done, for that testimony to be included by the chair of the public inquiry in the public inquiry. So ideally, in an ideal world, we would have by this point met the chair or the chair designate of the public inquiry and be having discussions about exactly how that works. But certainly our understanding of this whole process from start to finish is to be trauma-informed, non-adversarial. So if the chair of the public inquiry wants to kind of row back from that, that would be absolutely against the whole principle of how this process has worked so far. So clearly the testimonies that we have taken, we've asked people to consent if they are happy for their testimony to go to the public inquiry, and most people have consented to that. So we have, a large number of testimonies that are sitting there and they're ready to be either looked at intensively by the public inquiry, or they can accept our analysis of those testimonies, which we're currently engaged in, and we'll have a lot of detail about what they include, what are the major themes that come from them. So we would certainly envisage that feeds very much into the work of to the heart of the work of the public inquiry. I don't know if you want to add anything on that.
Okay, I suppose just following on from that, Sean, last week, I don't know whether you're watching, but there was a suggestion from the academics, for example, that the inquiry could actually be taken forward in sections similar to the COVID inquiry under different themes. And I'm just wondering, is that something that you think would be a useful methodology in terms of the inquiry? Good.
Thank you, Chair. Yes, I think that certainly makes a lot of sense. It would depend, I suppose, on the chair to determine how that might be done. The suggestion, I think, from Dr. Gallen was that it might be done by reference to particular organisations or particular groups, and I think that makes sense. And in particular, it would make sense to focus on institutions where the cohort of witnesses and victims and survivors is likely to be older, so that that evidence is taken first. But the modular approach has worked in other public inquiries, and we think that certainly it could work here too. Okay, thank you. I think you've covered quite a lot of the issues both in your report and verbally today, but I just want to highlight the issue there, a suggestion you've made around the inclusion of birth mothers of deceased children who would, but for their deaths, be eligible for the posthumous redress claim. Just wondering, could you speak to that on the basis of the testimonies that you have taken from birth mothers in those circumstances? Thank you. Yes, well, that relates to the fact that at the moment the eligibility to make posthumous claims essentially proceeds in a descending line. That is to say that it includes spouses and children. But it seems to us, in order to treat that there should be no hierarchy of survivors, that where a child who would have been eligible for redress dies, that the birth mother of that person would also be eligible. I suppose part of this issue as well relates to the issue of acknowledgement and perhaps the conflation of financial redress and acknowledgement, and this issue of financial redress being essentially the only form of acknowledgement that's contemplated by the bill. And it's for that reason that we're recommending that perhaps some other form of acknowledgement. Last week, I think Professor Magdalene and Dr. Gallen suggest the possibility of letters. That's one possibility, could be explored, so that actually the redress service would have more options simply than financial payments. Okay, and sorry, just a wee small supplementary to that, and it's really around the potential that we could recommend that the Executive Office, for example, could possibly come forward with the apology before, where usually you would have a recommendation in an inquiry that the state apology comes afterwards. But I'm just wondering, given the age of a lot of the people that you have been engaged with, do you think that it would probably be better that the apology just came from the start as opposed to waiting till the end? Well, certainly the age of the participants would certainly support such an approach. But equally, there can be levels of acknowledgement and apology that are staggered to take account, of course, of what is already known, what will be known when this panel reports, and then also what will be known when the public inquiry reports as well. Sorry, I think I'm going to Carol next. Sorry, I lost track there. Carol, do you want in?
Yeah, it's just around the compellability of the institutions. I know you were listening in to the previous panel members, but it's we're hearing it practically a lot if you're watching. there's a frustration with the process up until now, because as you say, the apology hasn't been forthcoming from the institutions, and certainly the money, which is part of redress, hasn't been forthcoming either. So it's just your thoughts on the compellability of the institutions. And we've since received additional names of institutions, be they private nursing homes, since the publication of this. So it's just your feelings on that, first of all.
Well, in relation to the compellability, I think the issues that Ms Murphy raised earlier on in relation to the legal issues that arise in relation to that are real. But if you look at international experience, there are other ways to, shall we say, to exert pressure on institutions to contribute to redress schemes. In the United States and in Canada, it was done through a reform of the statute of limitations, and it was done through so that essentially it was easier to sue these organisations for people, and that they therefore had an interest in contributing to a redress scheme which might prevent them being sued. That was one way of doing it. And then the other thing is that they adjusted the rules in relation to class actions, so that it would be easier. Now, it may be that the panel who spoke to you before would have some views in relation to what would be the necessary amendments to Northern Irish civil procedure that might exert the same kind of pressure. But I take the point in relation to actual compellability in circumstances where an inquiry hasn't reported yet. That could be, there could be convention compatibility problems with that, I think.
And then I suppose that the issue around access to records, I mean, you will know from the personal testimonies of people, every time there's an attempt to access records, it's just traumatising. So, and we've heard that, not from all the health and social care trusts up until now, but many of them, bar one, I think have started the digitisation process. And if the money was found tomorrow, it would still take them a clutter of years to get that done. So it's just in terms of, is there anything in the bill you think needs amended, in your opinion, to ensure that access is given?
I think access to records is a huge issue, and it has the capacity to negatively affect both the public inquiry and the redress scheme. I don't think there's necessarily anything in the bill that can be done to move that along, but certainly on the part of the Health and Social Care Trusts and on the part of the other private agencies, there are long delays in the processing of applications for records, whether those are made under the adoption legislation or whether they are made under the UK GDPR. The rules in relation to those are the same. Even where they're complicated, they should be processed within 90 days. That isn't happening. And it's not happening through any fault of the people who are processing those applications. Generally speaking, based on our surveys and engagement with victims and survivors, when people actually get the records, there isn't the same problem that there used to be with lots of redactions. And that's because quite good guidance was issued by the Department of Health, developed in consultation with victims and survivors. The difficulty is that now people are waiting a long time for these. Anecdotally, we're told that people are being told that they'll be waiting potentially a year. Clearly, if a person is evaluating whether to participate in the public inquiry, that's going to be a problem.
Exactly.
It's going to be a problem for the redress scheme as well, in terms of people trying to substantiate their claims. And then it is only going to get worse, because when the redress service and the public inquiry start looking for records, then there's going to be a huge, logjam of applications for records. So we have raised this at the highest level. We have met with the Minister for Health, and he assures us that he is doing what he can to work with departmental colleagues to get resources for the Trust to process these. But having checked with the advocacy organisations last week, they're not seeing a decrease in the times that are being taken to process these records. So it's a massive issue that has the potential to be very problematic for both parts of this bill.
Thank you for that, because we aren't seeing any decrease in terms of people getting access either. If anything, I think, as you've really described it very well, the anxiety has grown as the prospect of the inquiry approaches.
We've done an engagement piece with victims and survivors, a survey, and the results of the survey are very stark. Like, the experience of people looking for records is very negative.
Yes,
and it's important to say as well, we sometimes think of access to records as a form of redress, and that doesn't quite capture it, because it's actually an ongoing human rights violation.
Yes, it doesn't cut it. For me, the last question is about core participant status. How do you feel about that?
Well, I think the Mucklemore Abbey Hospital inquiry has a lot to teach us about how this inquiry could be done, and maybe that's something that the committee could explore with the people who are running that, whether it's the panel who are there or the people who are working for them, because they have put in place systems whereby core participants are represented jointly by teams of lawyers, so that cuts down on cost, obviously, but they also have remarkable rules in relation to participation by vulnerable witnesses. They take the view that all witnesses are potentially vulnerable, and that comes back to a point that you made earlier on, that yes, of course, the victim and survivor witnesses are vulnerable, but the institutional witnesses could be very elderly. In some cases, we're talking about institutions that closed 30 years ago. So there's also potential vulnerabilities there that you need to account for. I think that inquiry could be very useful in terms of steers. Now, in relation to that, I think that it would make sense to incorporate that into the regulations or the rules which can be made by the Executive Office, rather than leaving that to the Chair, particularly if it's going to be a single panel inquiry.
So we put it in now rather than
I think you don't necessarily have to put it into the legislation, but obviously with it, you'll have supervisory authority, I think, also over the regulations and the rules which will be made by the Executive Office to give effect to that. And I think it's in that situation that you put those in.
We won't see the regulations until after legislation's passed.
No.
And it's a question of trust.
It is, yeah. But I mean, on that, another thing that comes to the trust is, it relates to the issue of participation. If you have victims and survivors on the panel, victims and survivors and the Assembly and the committee can have more faith that it'll always maintain a victim-centred focus.
Thank you very much.
Okay, thanks, Carol. Philip, please.
Thank you, and apologies for missing part of your representation. Just the one at the start, you had mentioned, if you could go back to that, did you say something about discrimination laws? I just wanted to...
I said in relation to workhouses, that the reason the workhouses were included was because the women who were in them, who gave birth in them, who were resident in them, were essentially subject to the same kind of discrimination that the people were subjected to who were in the mother and baby homes, and in a different way, obviously, in the Magdalene Laundries as well. And I think that was the logic, as I understand it, of the inclusion of workhouses in the Truth Recovery Programme.
Yes, perfect. And then just in relation to the date, so your view is, as was the previous and most of the people so far who have came to the committee since I've been on it, that 1922 should be the cut-off.
Yes.
No one has been able to provide any figure on how many people that would bring into scope. I'm just wondering.
We did ask the Executive Office about that, and they did give us some numbers. Now, they didn't give us, I don't think, the actual numbers of people that would be involved, but they estimated that to backdate the existing redress scheme to 1922 would involve, I think, it would be in excess of £20 million.
20 million?
20 million pounds.
Okay, and then just...
But that's information, like, they did do the calculations in relation to different dates, so the committee will be able to get that information from them.
And then the final point was just, as Carol articulated very well, is the committee's desire to try and force the institutions to step up, but your view is on this that this bill probably isn't the right place for that. Yeah. Okay, that's 100%. Thank you so much.
Okay, thank you. Timothy, please.
Afternoon, thanks for coming. You refer to the victims and survivor colleagues. How many people do you represent?
Well, we don't represent anyone. We just have 3 victims and survivors who are on the independent panel. They're not representatives as such, but they do bring the lived experience of contact with these institutions, and it's absolutely invaluable in terms of like every single decision that the panel takes. Everything we do is informed by that perspective, and that's why I was making the point about participation in the public inquiry as well.
Yeah, talking about more options and financial payments. We had covered about the apology. The services after, so people that are coming and the trauma this will put them through. Has there been any discussion regarding services and support that will need to be in place after the inquiry? And you have had any thoughts?
People who participate in our processes, and obviously people who participate in the public inquiry as well, are eligible for assistance which is provided through the Victim and Survivor Service by, I suppose, community partners. And our experience of those community partners is very positive, though they are, I think, they probably have resource issues and capacity issues that will.
Are you hearing any concerns come back about services that currently exist?
I think there are some concerns in relation to capacity and waiting times for contacts, but I think that's probably a question better put to the survivors' organisations and maybe also to the advocacy organisations and the VSS itself.
Regarding your meeting with the Minister,
yes.
So obviously the Minister is very aware of the concerns that the committee has. No doubt you've articulated your own. Being aware of them and doing something about them is two different things. How confident are you that when people do go to get their records that we're being proactive, the Minister's being proactive to ensure this won't be a problem? That's a massive red flag that has come up time and time again.
Well, that's absolutely true, Mr. Gavin. I mean, it's the committee's been told time and time again that language matters. That's true, but action matters as well. And we are not seeing changes in the timeframes within which people are getting their records. And unless that changes, there are going to be very significant problems in relation to both the public inquiry and the redress scheme.
Once you raised that with the Minister, what was his response?
Well, I think his response was that he would do what he could to essentially increase the administrative records, the administrative support that was provided to the social work teams. Now remember, it's social work teams who are doing this, and social work teams have modern social working to be doing as well. And we know from victims and survivors and from advocacy organisations that some of these social workers are coming in the evenings, they're coming in at weekends to try to get through these applications. But our concern is both that there are issues in relation to the cataloguing of these. Now, Prony are helping the trusts in relation to that, but I think the point has already been made at the committee that that is still going to take a long time. And as I said, we're not seeing improvements in the timeframes in which people are getting records.
Is it resourcing, financial, or a mixture of both?
I think it is a mixture of both.
Just to come in on that as well, to say that the Western Trust, which was the trust that there was particular concern about the storage of records, from the Public Record Office have surveyed all of the trusts, all of the adoption records, welfare records that are held by trusts. The majority are held in outstorage, which is commercially run, and they have, in all of their reports, they have expressed concerns around it because the environmental standards are not archival standards. Some of these records are very old, some go back to the 1930s. Adoption records over 75 years should have gone to Prony. Many haven't, and they have identified that they're at risk, particularly of mould and of pest damage. Now, that they're in the majority of records that are in outstorage. The records in the Western Trust were in an old asylum workhouse building. There was a lot of damp, a lot of mould, and they are in the process of being moved, and they're applying for funding to make sure those are housed better. But in general, there is a big concern about the way in which records are held and the conditions that they're being held in. So there's this it's a resourcing issue, it's a financial issue, and it's how those records are managed. And one thing that the panel has been working on and will recommend is around an independent permanent archive, which would house the records relating to all of the institutions, processes and adoption records as well, so that they're looked after safely, they're looked after properly, and that with the restrictions and the safeguards, because this is very confidential information, but to try and get past these huge issues that there are around records, and often the re-traumatisation that people have in going back to an institution to ask for the records having been in that institution.
And there's also the difficulty of identifying the institution. Now, we have access to records guidance on our website that tries to map that, but for some people where they don't know exactly which institution, it means applying to multiple different trusts and organisations, which is obviously very difficult for people.
But
and
you had a central point.
Exactly,
Yeah.
exactly.
And
Everybody agrees there needs to be a central point.
There is, for example, one trust may have a list of all the records they have. There are some trusts that don't have a list of all the records that they have, and there's no centralised list. So you think, I was adopted, and this is specifically about adoption records, but I was adopted in the Western Trust. They don't have a list. They have to manually go and look through boxes to try and find out and come back and say, your records aren't here. And then you move on to the next trust. So given, as we've heard, the length of times that it's taken for a trust to come back to you, this extends the process even further and makes it hugely difficult for people.
Clerk, just on that, we were waiting for one. Is that still the case?
Yes, Chair, thanks. Yes, we are, and we will chase again, but to date we haven't had anything from the Belfast Trust.
Can we make an action on the back of this regarding some of the concerns we've heard, just to try and get a priority put on trust that's outstanding, and also about the one central location and how beneficial that would be?
To do that, if everyone's agreed.
Right.
And the reports, the survey reports from PRONI of all the trusts are all available as well, so that might be useful to see too.
Is that you finished, Timothy?
Yes, that's me.
Yeah, okay, thank you. Just thought of one other issue that sort of run through most of the evidence sessions, and that's the issue of people who gave birth in the north and their child was trafficked or moved to the south for adoption and vice versa. And I'm just wondering to what degree the testimonies you've taken relate to those scenarios, like how widespread was that, and how that practice could be better reflected in either the inquiry or the redress. I'm just wondering if any of the panel members have a view on that. Thank you.
Well, certainly we have a number of testimonies where children and adults were moved across the border in whatever fashion and in whatever circumstances that happened, often to an institution called Farn, which is in County Donegal. And often many of those children and adults then came back across the border and perhaps were adopted by families in Derry. So certainly it features very significantly in the testimonies. I'm not sure what the percentage number would be, but it's reasonably significant. And we do have a lot of records which indicate who those children were, who those babies were, and particularly those that went to Farn in terms of where they were adopted, whether they were adopted south of the border or north of the border. So there will be quite a lot for us to say in the report about that matter. I don't know if you have anything to add on that, Leanne, in terms of the records.
Yeah, the records, and we do have access to the records for the Nazareth home in Fawn, so we are able to see sort of the extent of that, and you do see it's babies who are born in Northern Ireland, they move south, they're sometimes then adopted back in Northern Ireland, sometimes they're adopted in the south. There doesn't seem often to be a pattern about whether it matters whether the birth mother was from Northern Ireland or not, in a sense what happened to the baby. So it is in the thousands, and there are several other institutions, but Fawn would be the largest one. And as it operated as the sort of baby home for that kind of those sort of Catholic dioceses, that was where the border simply doesn't appear to have been a factor or been considered in terms of that movement across, and it particularly for mothers who were from those kind of more Western dioceses, then that would have been that was the sort of movement often there as well.
Okay, thank you very much. I'm not seeing any other indications for questions, so thank you all very much for coming today, and I say thank you for your submissions. Clark, I think there might have been a couple of actions there. I wonder if you can raise those. Thanks.
Yes, no problem, Chair. There are actions from both of the sessions that we've had, so I'll run through the ones that I've captured, if that's okay. So firstly, in relation to Clause 26, that's judicial review and the amount of time that the bill currently allows for applications to happen. I suggest it's clear that we need to write to the department to ask them, why it is 14 days and to get their rationale behind that. And obviously that's something that is now flagged up to the committee. The second one is that's come through in both of them is around the core participation status, and that's something that currently is silent. So again, Chair, I would suggest that we write to the department asking whether it's something they've considered. If they have considered it, have they ruled it out, or what is the reason behind it not being part of the bill as drafted now? It may well be that comes up as part of Clause 27, which is the rules that actually will provide the framework for the inquiry. And just to remind members, we are getting legal advice on how that would actually operate in mid-November. And also just to flag up to members at this point that anything that comes in regulation under Clause 27 currently is subject to negative resolution, not draft affirmative. And I know that's something that had been highlighted to committee before, and that's something that we are pursuing as well. The third point that I got was just alternatives to compulsion. In other words, are there other ways that perhaps the department have considered in which they could, for want of a better phrase, exert pressure on institutions to perhaps provide redress funds or the like? So again, I think we can ask the department whether they've considered that and whether that is appropriate for the bill or perhaps for the next stage. The investigation and inquiry into Muckamore Abbey. Obviously, the witnesses who've just left did suggest to the committee that it might be worth trying to actually have a look at the way in which that was structured. We are a little late in the day, I think, to get formal evidence on that, but perhaps if you leave that with myself and the team, we'll try and get information on that we can then bring back to the committee.
Reports come out.
Yeah, we'll ask research services as well whether there may well be research already available on that, and we'll certainly come back to the committee on that. And then finally, again, it's something that's come up in every evidence session that we have, but specifically whether the department have a cost on going back to 1922 in terms of posthumous date, whether there is I know that our previous witnesses had sort of mentioned a figure of 20 million, but whether there is something a little bit more accurate than that the department have. So again, just to ask that. That's what I had come up with. I'm happy to take any more suggestions.
Sorry, so they may well have provided this to us before, but what were their projections for HIA and what was the actual outturn in the end? And I think that would probably give a better indication of the high level figures against what the actual level of applications and amounts were.
That also, sorry, just to say, in the EFM, they do give cost of claims, whether being a low scenario, a medium, and a high, but that is based on the 2011 date, so not to 1922, which I think would have a significant effect on that. But yeah, so we'll go back on that as well.
How to get rid of a cat. The second one then was maybe if we could maybe ask Ray's if they could pull together a paper very quickly just on that Muckamore, because I know a lot of the parent groups, the campaigning groups, they've had a lot of public utterances of how they feel that the public inquiry didn't represent their best interests, etc. So that might be something that could be pulled together quite quickly, if that would be possible.
We'll certainly ask them. I suspect there is probably already information there, but yeah, we'll go back to them on that urgently.
Okay, thank you. Anybody else got any other?
So I think both Philip and Timothy have indicated.
Okay, go ahead.
Thank you. So I was just keen to get Claire Keegan's McKeegan, view on, so in her written evidence on behalf of Phoenix Law, she had raised concerns in relation to clause 14. But then when I asked was she content with the safeguards then that were provided for in relation to 15, she wasn't quite sure, so I'd just be keen to follow up just to see if she thinks that the safeguards set out in clause 15 negate her concerns in relation to clause 14.
No problem.
Maybe not a follow-up, but just at some stage, I just think we as a committee need to discuss the issue around core participation status. Whether there's clearly merits and demerits of that. So I don't know. Maybe it predates my time, but have we had a discussion at the committee about it? Yeah. No. Okay.
Sorry, Chair. If I may, an opportune moment for that might be that we are, as I say, we are due to receive legal advice on the 14th of November around clause 27 and protection for witnesses. It could well be that I can ask legal services if they could also just incorporate co-participation within that, and we'll get some briefing on that then, and can have a discussion.
Not me saying it, but a cynic would say, obviously, legal firms are going to say that there needs to be core participation, because ultimately then that could see a blank cheque being created for them to benefit from. So
monopoly.
I just think we need to have a look at that. And the only other, the numbers of night. So they both confirmed, and I know they represent quite a lot of people in terms of clients. None of the clients of either Kevin Winters or Phoenix would be impacted by that change, bringing it back to 1922. Isn't that what they confirmed? And then also, is that the first time someone has put on the record, so that was the chair of the panel, that they didn't, but that whilst, just like the committee, we all support mandatory contributions from the institutions, but their view is that this bill isn't the right place to do that? Is that the first witness that have said that?
As far as I can, Chair, if I may, they're the first witnesses who have said that.
Okay.
I can't think of any others who haven't checked that for you, but off the top of my head, no.
Okay,
just come back
Timothy and then Pam, please.
Just come back on the records. What they've said about the Western Trust and the condition, the concerns they have regarding pests and mould. Is there any chance we could get somebody from the health department to come and speak to us about that, or where they are? The last panel have met the health minister over the issue. I would like more information of what's being proactively done, because I get the feeling that there's not very much. So we have made representation and wrote off a number of times, but we're still talking about it a number of weeks on.
I think if we, on the first instance, Chair, let us chase up the Belfast Trust and get their response to the initial inquiry that we had made to them. I think we can then perhaps go back to all of the trusts asking, but in specifically to the Western Trust in terms of the environmentals and the state of theirs, whether we can get, we are pressed in terms of time to fit in verbal evidence from the Western Trust, but certainly we could ask for an urgent written submission, which can then be incorporated into our deliberations.
It's not so much hearing from the Western Trust, it's hearing from somebody within the Department of Health regarding having all the records in one place so that it can be accessed. My understanding is that if you were adopted, you couldn't be adopted in the same county you were born in. So if there is a large number of victims out there that don't know what institution they were in, it's highly likely then they'll have to look at all the institutions that weren't in the immediate county that they were adopted in. So that would likely be that they would have to go to a number of trusts to search for the information. I have no idea if that's a small number of people, a large number of people, but I just think that the Department of Health could do more and should be doing more.
Well, slightly different action than we, as a committee, can certainly write to the Department of Health, obviously copying in the Health Committee as well, and just ask those very questions.
I think it is, that's where you go, not to the trust, because they are coming back and telling us what they have. There needs to be a central action taken if they're going to have all the records in the one place.
That's fine, that's no problem. I think Carol and Pam as well, Chair.
Sorry, I think Pam was just in before Carol, if that's okay. Go ahead, Pam.
Thank you, Chair. Those were very good sessions, very useful. And my query was around actions as well, really very similar to Timothy there. My concern about the access to records, and it just strikes me. Obviously, we're looking at it in the context of this bill, but just as a generality, I think it's horrific that that it's so difficult to access these records, and it is clearly going to become an even bigger issue with the progress of this bill. So I don't know what we can do in terms of speaking to Department of Health, but even something in a written format in terms of what plans the department have to actually be able to cope with the further need that there's going to be in terms of access to records. And it just strikes me too, also, Chair, you'll be well aware of how much over the years we've talked about Encompass, the system which is now all rolled out. Surely there is great potential to add in all these types of things and ensure that this type of thing can actually, surely it should be fairly easy to centralise, given that we have Encompass rollout across Northern Ireland. So I just would like to be delving a bit further into that as well to see what practically could be done. Thank you, Chair.
Thank you. Carol, please.
So, I mean, PRONI's the public repository for all these records. It would be easier if the Trust just sent them all to PRONI and let them process them. They've got the conditions, they've got the wherewithal, they've got the experts, you know, because if we, I mean, the Belfast Trust can just about cope with Encompass at ED. You go further than that, there's an issue. And Pam's right, you know, it'd be great if you could access it all digitally, but it's not going to happen for this. So I just want clarity on what are we bringing legal advice in for? Clause 27?
Yes, there are two things. We've got one, we've asked for legal advice on clause 27.
Which part?
Specifically around, hold on, sorry.
Negative resolution?
We've already had that. So it's more around in terms of the protection for witnesses and whether what there is within there that at the minute it's quite ambiguous in that what rules could be brought, and so it's just to get clarity for the committee on what could be actually, if there was something that we could amend to put in there to make sure that certain protections were there. The other area that we've asked for is that you mentioned earlier on, Carol, is the non-FOI route, and we have asked for legal advice on where does that actually stand now in terms of other legal ways in which members of the public may try and access records.
Okay, so that's fair enough, because I mean the last bits of legal advice we got, it was a masterclass in not committing to anything, frankly. It was absolutely brilliant. So we are going to need to probe the advice. The thing I want to ask about in terms of the modular approach and core participant status, and again, conflict of interest, because I sat in the COVID inquiry, because I was in the covering for Deirdre for 6 months in DFC. But the families got core participant status. There could have been 10 families or 105 families or whatever. They all got the core participant status, so they had the one legal team. But as did the executive and other departments in the executive get it. So it's not like, I understand your point about legal fees, but the HIA, the institutions got core participant status and the victims and survivors didn't. And it was horrendous. It was, I mean, that's the part that I felt was so traumatic. So we're all conscious of the impact this is going to have on us, rather than in terms of money. So I still would like to see legal advice in terms of compellability. Irrespective, I appreciate what the panel had said, but if we don't get it in this bill, we're not going to get it, and they're not forthcoming now. So
just to clarify, in terms of when you say compellability, You mean in terms of records or in
No,
terms of
no,
money?
in terms of money.
In terms of money.
Yeah, compel them to pay. So you could be looking at things like statutory obligation,
Statute limitation.
yeah, statute limitation extension of potential. If we could write to the department and ask them have to look at the potential of extending class action rules and
Yes.
civil litigation
Yes.
in advance, because I think coming from the department even before this inquiry happens would be helpful. It's not going to cost them anything, and then so that's that bit, and then to look at if we could ask even the TEO's civil contingencies who dealt with the COVID inquiry, maybe. Although they weren't the ones who come up with a modular approach, but certainly in terms of, or even research, you know, how that worked out.
We wrote to the department off the back of last week's meeting asking about modular approach and whether it's something they considered. But certainly we can ask specifically around the COVID inquiries to the structure of that. Yeah, that's no problem.
Okay.
Okay.
Okay, thank you. So, were there any additional actions there? We just maybe need to read in the end of the record there, Clark.
No, I think we've captured all of those.
Okay.
All of those there just during
Okay.
this discussion. That's right.
So everybody's in agreement then there?
Yeah.
Okay.
Right.
Okay, thank you. Okay, members, moving on to item 9, correspondence. I'm going to refer you to pages 200 to 204 of your pack for the summary of committee correspondence. I would just like to draw your attention to a number of items. 9.9, TEO clerical abuse query. You'll find this on pages 268 to 269 of your pack. Just to advise that the department has responded to the committee's correspondence of the 12th of September regarding the inquiry and redress scheme bill and a query surrounding clerical abuse, which the Committee for Justice has raised when responding to its views on the inquiry bill. So just to advise, the historical clerical child abuse issue is being considered as a separate process, and the interdepartmental working group has commissioned the research and ministers are now considering that. So just ask you to note this item of correspondence and to agree to forward it the response to the Committee for Justice for Information. Agreed?
Great.
Okay, 9.10. So this is I'm going to refer you to pages 270 to 273, and it's in relation to the establishment of the Castlereagh Foundation. Just to advise that the department has responded to our correspondence of the 24th of January this year in relation to the establishment of this Castlereagh Foundation. And just to advise, it will be the responsibility of the Office of Identity and Cultural Expression to establish the Castlereagh Foundation, which will be financially and operationally independent, and the office, the Irish Language Commissioner and the Commissioner for Ulster Scots and Ulster British Tradition preparations are now at an advanced stage. So just ask your agreement to note this item of correspondence and to agree to write to 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 ask that following the appointments to the office, that they ensure that the establishment of the Castlereagh Foundation is a key priority for the incoming commissioner. Are we agreed?
Great.
Great. Just on this issue, I am concerned of the media reports that there has been a delay in progressing. I think they've identified the 2 commissioners. Their names are out there in the public domain, but in terms of the Irish language and the Ulster Scots and Ulster British traditions commissioners, that there does seem to be some blockage in the system, and I'm just wondering, members be content that we write to the Executive Office to ask for an update in terms of the appointment of those 2 commissioners.
Great.
Okay, thank you. Okay, so I'd just like you to bring in the clerk now in terms of actually reading some other items of correspondence into the record. Thank you.
Thank you, Chair. Members, item 9.2, 9.3 are Hansard reports from the sessions the committee had with Adopt an Eye, Victims and Survivor Service, Wave Trauma Centre and departmental officials on the meeting of the 24th of September. Item 9.4 is from the NI Judicial Appointments Commission, and that's an invitation to members to an information session on the 17th of November. Any member who does wish to attend should contact the NIJAC directly using the email address within the correspondence to register their attendance. Item 9.5 is Public Accounts Committee, a memorandum of reply on major capital projects follow-up report. This is for members to note. Item 9.6, Committee for Finance, performance appraisals for the head of the civil service, again for members to note. Item 9.7 and 9.8 are the 45th and 46th reports of the Examiner of Statutory Rules, and just to note, there are no rules for the attention of this committee in those reports. Item 9.11 from the Victims Payment Board, response to complaint regarding Troubles Permanent Disabled Payment Scheme application, again for members to note. Item 9.12 is a copy of correspondence from the Department of Finance to the Committee for Finance regarding the Administrative and Financial Provisions Bill. Item 9.13, correspondence for the Committee for Finance on the October monitoring round, for members to note. Item 9.14 is the departmental response to committee correspondence of the 27th of January on October monitoring in relation to communities and transition and the Windsor framework. Item 9.14, again correspondence from the department on communities in transition phase 3 contracts, and a table has been provided detailing the area issue, contractor and contract value within phase 3. Item 9.16 is a written statement from TEO, the Executive Legislative Programme for 25-26, and it was worth members noting that the Department planned to introduce the Race Equality Bill in this parliamentary session, and also that there is a motion on the order paper for next Monday on a debate on this subject. Item 9.17 is individual correspondence in relation to evidence of exclusion of workhouse mothers for redress. And I'd just like to note to members that that correspondence will also be added to the bill pack that you receive on a Friday. And finally, item 9.18 is a Northern Ireland Office press release on the new UK Connect Fund.
Okay, thank you very much. Anybody want to raise any issues in relation to correspondence?
No.
No, Chair.
I have an issue, but I think it's probably more for forward work programme, and that's around the Judicial Appointments Commission. But I wonder if the committee team there could possibly pull together any correspondence that we have received to date in relation to the race relations order. I think it might be useful for us in terms of our response to the debate in the chamber, if it's available and to hand. Thank you.
No problem.
Okay, so I'll bring in. Move on to the draft forward work programme. I'm going to refer you to pages 382 to 384 of your pack for the updated forward work programme, and to ask the Assistant Clerk if she would talk through any changes to the programme. Thank you.
Thank you, Chair. So it's just to say, obviously next week we have no formal committee meeting, as we're out in Dungannon in the morning and Oma in the afternoon for the 2 round tables. And then on the 22nd, just to say again, the round table in Europa is in Belfast at 10 a.m. in the morning, and then we will have the formal committee meeting in the afternoon at 2 as normal. So if any member hasn't said that they're attending those, just to let us know, obviously in terms of spaces on the bus and things like that, just so we can get it all organised.
Okay, thank you. Okay, so I would just like to raise the issue of the legacy framework. I think we've touched upon it very lightly since the revised proposals have come forward from the Secretariat of State. And I recall that we wrote in the past to ask for the committee to be updated on those proposals, and the response was that they would be prepared for the NIO to give us a briefing in private, because the Northern Ireland Affairs Committee had not yet had sight of the proposal framework. So I just wonder, is this an opportune time, as we know that that this will be coming before Parliament shortly? Would this be an opportune time to go back to the NIO and ask for that oral briefing session in public, an open session at committee?
Yeah. Agreed.
Okay, I appreciate we're busy scrutinising the bill, but hopefully there'll be an opportunity to slot that in somewhere in the near future. Anybody else got any other comments to make on the forward work programme? No. Okay. Any other business, members?
No.
No. Okay. So just as the Assistant Clerk has just said there, so the next meeting will actually be on Wednesday, 22nd of October at 2 p.m. in this room. And just to remind that we will be having these 2 stakeholder roundtable events next week. in Dungannon and Omagh, and I would encourage anyone who would like to provide their views on the bill to attend one of these sessions. The Dungannon roundtable will take place at the Hill of the Nail building in Market Square, and the start time will be 10:30 a.m. And the committee will then move on to Omagh, and that will be in the Silver Birches Hotel for the second session, and that will be starting at 1:30. So if anybody watching online today would like to attend, if you can get in contact with the committee team or check the Assembly website under our page, you will find those details. Okay, so is that everything for now, Clark? Is that, yep?
Yes.
Okay. So the meeting's adjourned. Thank you.
Okay.
Committee Room 21. Sound. 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 Committee Room 21. Sound.